Do they keep going that way, or they're just meeting maybe over there?
I think they're having a
powwow. Yeah.
Julie, can I have this just cup?
What?
Since I'm the first, can I just have this cup?
No, why not?
Okay.
Oh, a little big group like that.
Yeah.
Did you want to sit, Matthew, did you want to sit next to me because Bart's not going to be here? Just let me know the spot. Just the one item. Did you want the agenda and stuff? Oh, you just did the second part itself. the first
Yeah,
thing.
yeah.
Okay.
I just,
Well, that's just the agenda, which only has that item. Okay. Okay.
but you stand up, you won't get into the camera. When I shoot your speech, one.
Can you
Well, you know, have another one. Pretty. I'm sorry? I think it's right there. Both, but I think he's she's enough chairs. I hope not. How are you? Nice to see you.
Nice to see you too.
It's my wife, Susanna.
Hi, Susanna Catherine Roulette. Nice to meet you. Nice to meet you.
We have a full house here.
Did you send it? What is
They
it?
say you can. I think it helps them with their.
Right up on the record.
Yeah.
I'll take it.
She can write your name and obviously it helps them with their list and who is talking.
Is this the same one as the last
No, using the big room that has jazzy sounds.
one? We got relegated down because of
Well,
taxes.
because there's only, this is the only thing on the agenda tonight. A special meeting is for us.
Is the microphone located here or at the front? Okay, thanks. Just want to make sure.
Yes.
That would've been kinda funny, huh? Good evening. Welcome to the special meeting of the Costa Mesa Planning Commission on December 17th, 2018. I will call the meeting to order and ask Commissioner Harlan to lead us in the Pledge of Allegiance. Thank you, Commissioner Harlan. Roll call, please, Julie.
Chair Andranian absent. Vice Chair D'Erico.
Here.
Commissioner Harlan.
Here.
Commissioner Navarro-Woods absent. Commissioner Zick.
Here. Staff, I heard from Chairman Andranian about 45 minutes ago, and he will be here in about 20 or 25 minutes. Have we heard from Commissioner Woods at all? Okay.
Only that she planned to attend.
Okay. Okay, very good. We don't have any announcements or presentations tonight, so that will take us to public comment. To ensure fair and equal treatment of all who appear before the Planning Commission and to expedite city business, speakers may be limited to 3 minutes during public comment to speak on any item within the Planning Commission's jurisdiction which is not listed on this evening's agenda. This time may be extended for good cause by the chair or by majority vote of the Planning Commission. If there is anybody here to speak on public comment tonight on an item not on tonight's agenda, it would be great if you fill out a card. You don't have to, but it helps the Planning Commission secretary. Do we have anybody here this evening wishing to speak during public comment? Okay, seeing none. I will close public comment, and that brings us to commissioner comments, and I will start with Commissioner Harlan. Do you have anything tonight?
No, nothing tonight.
Okay, thank you. Commissioner Zick.
Nothing tonight, thank you.
Okay, and I have no comments. So that will bring us to our sole public hearing tonight. This is a continuation of the public hearing of planning application 18-41. Julie, please.
Public hearing item number 1, planning application 18-41 for a marijuana distribution facility, Triad at 3525 Highland Avenue, Suite 265. This item was continued from the November 26, 2018 Planning Commission meeting to the December 10, 2018 meeting. At the December 10, 2018 meeting, the Commission continued the item to a special meeting on December 17, 2018. This is a call to report any ex parte communications.
Mr. Vice Chair,
Commissioner Zick.
so I had met with the applicant prior to the December 10th meeting and have not had any discussions with anyone since.
Okay. Okay, and I had just a quick telephone conversation with Chair Andranian this afternoon, only just to inform me that he was going to be late, but I want to make sure that that communication is on the record as well. So, Ms. Walsh.
Good evening, Vice Chair and fellow commissioners. My name is Caitlin Walsh, Assistant Planner. The item before you this evening is a request for a conditional use permit for a marijuana distribution facility in a second-floor suite of an existing multi-tenant industrial building. The applicant is requesting to operate under a Type 11 distribution state license. The original application included a manufacturing component. However, the applicant has revised the CUP to propose distribution only. Therefore, no processing, packaging, or manufacturing will occur at this facility. The project was originally scheduled to be heard by the Planning Commission on November 26, but was continued to the December 10th meeting, where it was reviewed by the Planning Commission. At that meeting, the Commission continued the item to tonight's special meeting, noting concerns with the proposed location of the outdoor loading area and the compatibility of the proposed use with surrounding office uses. As proposed, loading of pre-packaged cannabis products would occur in a parking lot shared with other tenants. The original loading area was proposed approximately 50 feet from the entry-exit door, and the applicant proposes to utilize odor-proof, locked and secured containers to transfer product to and from the delivery vehicle.
Ms. Walsh, if I could just interrupt you for the record, just to note that Commissioner Woods has joined the meeting. Thank you.
At the December 10th meeting, the applicant requested that the requirement for a designated loading area be removed in response to conversations with the building association. To support the applicant's request to remove the requirement for a designated parking space, the applicant has submitted information after the December 10th meeting demonstrating the intent to provide a video surveillance system that can ensure surveillance of areas within 150 linear feet from the proposed camera location. Staff has reviewed the information provided by the applicant. In the past, staff has required a designated loading area as a condition of approval for Measure X projects to ensure the proposed area is exclusive to and available for the Measure X tenant and within range of the proposed video surveillance system. From staff's perspective, without a designated loading area, the parking within view of the applicant's modified camera plan would not be exclusive and may not be readily available for use during delivery times. Therefore, the conditions of approval included in the resolution packet this evening remain unchanged. However, the Commission has the discretion to modify conditions of approval as deemed appropriate. As it relates to state law requirements for outdoor loading, the state does not regulate whether loading occurs indoors or outdoors, nor at what distance from the licensed premise. Additionally, state law requires cameras to be permanently mounted in a fixed location, as well as requires a minimum resolution for cameras. Additionally, surveillance of activities within 20 feet of all points of entry and exit are required per state law. Further, condition of approval number 40 broadens these requirements to ensure that all loading activity is monitored by security cameras at all times, including the path of travel. As with all Measure X applications, more than 30 standard conditions of approval related to Measure X are included in staff's recommendation this evening, including the recommendation made by the city's consultant, as well as conditions related to outdoor loading activity. With that, staff recommends that the Planning Commission adopt a resolution to find that the project is categorically exempt from the provisions of the California Environmental Quality Act and to approve planning application 18-41, subject to conditions of approval, approve with modifications, or deny the application subject to the findings for a conditional use permit. This concludes my presentation this evening. I'm available for any questions. We also have a representative from the police department, as well as Matt Eaton from HDL to assist with answering questions.
Great. Thank you, Ms. Walsh, for your report tonight. Commissioners, do you have any questions of staff?
Mr. Vice Chair.
Commissioner Zick.
Just one question for our security consultant. The 150-foot distance that is represented by the applicant as being acceptable for both identification and recognition level video capture. Have you looked at that, and would you concur that that is feasible?
I did review that, and that is feasible.
Thank you.
Okay. Commissioner Harlan.
Thank you, Mr. Chair. I had asked of staff after the last hearing to do a quick search, seems like it was a comprehensive search actually, of whether or not there were any CUPs existing for the current property. And my question was, it appeared from the report that you provided that there are no current businesses that operate under a CUP in the building. Is that correct?
That is correct.
Okay, thank you.
Okay. Commissioner Woods, any questions? Okay. I will open then the public hearing and ask the applicant to come forward, please. Yes, sir. Good evening. Just the question, have you read the conditions of approval and do you agree with them?
Yes, Mr. Vice Chairman.
Okay.
To be clear, we propose that the conditions 40 and 41 be modified as suggested previously by Commissioner Zick.
Okay, that's noted. Thank you very much, and you may proceed with your presentation.
Okay, thank you, Mr. Vice Chairman, Commissioners, City staff. We just have a few slides that we wanted to review more, just to recap from the last hearing and address some issues and open items that were brought forth at the hearing. So, Caitlin. We have provided evidence in the packets that you have, and just wanted to recap about 5 or 6 items. One regarding odor. I think we talked about this at length, but I wanted to be clear based on the last conversation. Our intent, independent of the products or the category, is to always distribute retail-ready, sealed, and odorless products. Everything that we will be distributing, I know we gave an example at the last hearing of some of the types of products, but everything that we plan to distribute will be sealed, odorless, and retail-ready. The other item, as Mr. Eaton at HDL has talked about, we have not. We are not aware, and I don't believe staff or the commission is aware of any issues or incidents regarding safety concerning loading and unloading at these types of facilities. We just discussed the issue around parking was just discussed. Also, we have provided the commissioners and city staff a letter from an industry expert that we had retained out of Washington, D.C. to discuss the facility clearance issue that had been discussed. And then concerning the HOA, I know there was representative from the HOA at the last meeting. We've had a variety of interactions with the HOA since we signed our lease to coordinate parking and other issues. Currently, the CCRs at the HOA do not prohibit the type of use that we've applied under here, and we have shown that there has been a significant increase in rental rates and sales at the facility. And in fact, as you saw in the packet, there's currently active listings that are promoting the use or the ability to use and operate cannabis businesses at the 3525 Highland Avenue. And then we've also provided a letter about insurability because we know that that was addressed in a previous dialogue. And then also there was some question about our corporate formation. We provided a letter as well from the attorney that helped us structure that, as well as correspondence from the IRS on that. Caitlin? Just again, I won't go through this slide in detail, but I wanted to again reiterate all the products that we intend to distribute will be odorless and sealed. We had some product that we distributed at the last hearing. We also have some pre-rolls because that was specifically addressed at the prior hearing. Those are all odorless as well. And you can see a snapshot of the types of products. But again, all categories of all products that we sell will be odorless and completely sealed and airtight. Caitlin? I'll touch on this just to reiterate. The reason that we were structured as a mutual benefit corporation was when Triad was established in March of 2017. The only available formation was a mutual benefit corporation, and that was the only thing available under the California Compassionate Use Act. Since that time, there has been additional laws passed, most notably the MAUCRSA, which it's a long acronym, which I won't attempt to explain, but that was passed in July of 2017, well after we had formed our mutual benefit corporation, which now allows both nonprofit and for-profit businesses. But to be clear, the fact that we are a nonprofit does not exclude us from paying taxes. We certainly intend and had always intended to pay taxes to the city as well as to the federal government, but it was the only mechanism available at the time. If granted a CUP, we intend to convert to a for-profit, although the existing structure is still applicable under state and federal law. Caitlin? Again, all of this is public record. Anyone can pull it up, but the property values have significantly increased in this particular building, certainly within the Measure X zone, anywhere from 50% to 100% in resale values. We've also seen lease rates that are up 175%. We are unfortunately on the receiving end of some of those lease rates, but all of that is for public record. And as you can see, there are two properties in the building today that are being marketed and promoted for use for cannabis. And then, as I mentioned before, the CC&Rs at the facility, even today, have not been amended, and they still allow cannabis use. Measure X was passed in November of 2016. Before we signed our lease, we did receive confirmation from the HOA that they were neutral on it, that they did not oppose or promote the use of cannabis businesses in the building, and since then 5 units have sold since Measure X have passed, all significantly above prior market rates, and about a third of the building now is being leased to cannabis or businesses that intend to operate cannabis in the facility. And as I mentioned to start, the CC&Rs as of today still have not been amended. This was concerning the question around facility clearance. We did hire an expert in the field. We apprised that individual of the situation in our building. He has provided a declaration stating specifically what is written there. I will not go through the details, but I personally have had experience running facilities cleared by DOD, and I'm well aware of the engagement with both DOD and DSS, but we have on the record a letter from an individual saying that any use of the cannabis in the building will not impact any facility clearance for an operator in that same building. We've discussed briefly the COAs for 40 and 41, which Commissioner Zick discussed at the last hearing. We are supportive and in agreement of the recommendations, and those are both outlined there on the slide. And then just to touch, we have a variety of cameras that we have researched. We fully believe that we can cover the parking independent of where the camera locations would be, but we have identified cameras capable of recognizing people and license plates around the facility. And Caitlin, you can see another camera position there. Anywhere up to 150-foot field of view is certainly capable with the technology and the cameras that we've looked at. And that really concludes our presentation. We just wanted to touch on some of the issues that were brought up. Mr. Vice Chairman.
Thank you, sir, very much. Commissioners, any questions for the applicant?
Vice Chair?
Commissioner Zick.
Question regarding the camera positions. Have these been determined yet by you, or are the drawings that you just showed, those last 2 drawings, conceptual in terms of the corner of the building and the vertex above the lobby?
So to be clear, those are conceptual, and the way they were derived is from the security camera company that makes and sells these types of cameras has a software program that they put in the features of the camera, the height of the building, and what you're trying to accomplish in terms of megapixels and resolution, and then that is a computer generated field of view. So just from an optics standpoint, if we want to capture a distance of 50 feet, then we can have a wider angle. And so that's why if you go back to the previous 2 slides, you'll see that if this was really meant, we're agreeing to your condition of 50 feet. So this is really just illustrative of capabilities of the camera in general. You see here that what you have, when you have a 50-foot range, then you have a wider field of view, so you need less cameras. And if you go back to the other one, when you try to get that type of resolution at 150 feet, then you would need more cameras. Frankly, wouldn't probably be a good decision to do that. But the 50 feet, you can cover pretty much cover the entire parking lot with a fixed camera. We chose, if we go back to the other one, Caitlin, please. We chose that because those are actually that's where our suite is. And so we confirmed with the security camera expert that there are cameras that are routinely used and available that would allow us to actually locate the cameras in the suite if that's what ultimately was appropriate.
And if you don't mind, sir, if I could just have the record reflect that Chairman Andranian is now with us at the meeting. Thank you.
So I had a follow-on question on both this drawing and the other drawing. So on this drawing, am I to interpret that you would have one camera on that corner that would cover all 3 of those triangles, or would that be 3 different cameras? What do you think that is representing?
So that's representing 3 different cameras, and frankly, that wouldn't be enough. We would need a 4th camera to cover the common area in the grass where the path of travel would be.
Got
So
it.
this is just representative of
Yep.
showing what the cameras can do. This isn't meant to
Right.
be a security plan.
Got it. And then the prior drawing, just to be clear, at the building vertex there, clearly a camera in that position wouldn't be able to cover the dozen parking stalls that are nearest the entrance off the street, correct?
So that camera in that position would not be able to cover, anything outside of that triangular field of view because it, probably, it's
Yeah.
higher than that. So it can't see through the building, obviously.
Got it. Thank you very much.
And then, just for the record, I'll note that I think we also have a letter from the security consultant. It's in the package of materials that you were handed out, and it's also referenced in the staff's report to you. And I believe that begins at page 83 of the staff's report.
Yeah, saw that. Thank you.
All right, commissioners, any other questions for the applicant?
I do, Mr. Chair. In your presentation, you had just stated something which I hadn't heard before, that a third of the businesses in this building are leased or plan to be leased for cannabis.
I think
Is that correct?
I think that's by square footage. That's our understanding, that a third of the square footage of the building. Our landlord, I think, owns 3. And there was an applicant that I think had a very large suite that they were applying for a manufacturing permit. That was turned down, but that was effectively like a double suite, I think. If we could get more particular information.
Well, maybe for staff, if we can verify that that's really the case. Is it a third by square footage or a third by units?
So it's our understanding that there are a total number of 18 suites, and we have had 4 applications for conditional use permits for the Highland address. We don't have a breakdown by square footage. We can try to put those together quickly. I'm not sure we have it in front of us to do that.
Does that include the shelf life application that we heard?
It does.
Okay, thank you.
And then the 5th one would be another suite that's owned by our landlord. So he has a total of 3. He had the shelf life suite. He has ours. He has a 3rd one. And then there's the other 2 permits. So that makes, by my count, a total of 5 suites.
Okay, thank you.
Commissioners, any other questions for the applicant? All right, well, thank you. I'm going to invite members of the public up to address the matter, and you'll have an opportunity to rebut or to provide a closing when they're done. All right, if you're a member of the public and you wish to speak on this item, please come to the lectern now. That we also have these speaker cards. They're not mandatory, but they help staff put together the minutes. So, good evening.
Good evening, City Council. My name is Matthew Vanslow. I am the security officer for 90 Meter Inc. I am speaking on behalf of opposing cannabis distribution at 3525 Highland Avenue. In regards to the square footage of the office building, Highland Plaza, as for square footage of the building, it is 46,958 square feet. I have confirmed with other tenants in the building, we have 32,020 square feet of the office building has been confirmed that they are against cannabis distribution. So 68% of the building is opposing, and that is a confirmation. The company I work for is 90 Meter Incorporated. We are a federal government contractor. I know in regards to the letter that Triad presented on the previous CUP was presented by an attorney, Mark Zaid. Now this is just an opinion letter. I have spoken to DSS as well as FBI. They have never dealt with this situation. Our DSS rep covers all of LA County as well as Orange County. She has not had to deal with this. So there's no policy in place for this. So the fact of the matter is there's no policy in place. So by allowing cannabis in 3525 Highland Avenue, you're now asking my company and my employees to take this risk with the federal government. We don't know which way they're gonna go. We do not know. So that is a huge risk for our company to take. If it goes the wrong way, we lose our contracts, we can potentially lose 19 employees to be unemployed. That is not a risk I'm willing to take, and I know that's not a risk that my employees would like to take. I thank you for your time tonight, and thank you. Have a good evening.
Any other speakers on this item?
Hi, Commissioners. Thank you very much for giving me the opportunity to talk. My name is Waleed Qazi. I'm the owner of two suites at 3525, 200 and 205. I oppose this CUP application because, again, we are an office building that's primarily made up of professional services, engineering, consulting, IT. There are no existing distribution facilities at all, and I know the applicant has said that the CCR allows, but I don't believe that's actually factual. The CCR actually says, and you have a copy of the CCR, that this is an office condominium project. It does not specify beyond that, but it, as the board cannot take a position because the board has to be independent of all the owners. So they cannot take a position against one owner or the other owners. But if you talk to any one of the board members, they are all, here, you will see they will individually say that they do not support this. Also, I will just make one comment. We went out and measured the distances that is, from the proposed suite to the loading unloading area, and it's 11 feet from the office to their stairs. It's 24 stairs that go down from there, and it's 15 feet from the bottom of the stairs to the top of the stairs. It's very steep, 24 stairs. It's 20 feet from the stairs to the door, and then it's another 75 feet from the door to the curb. So it's a total of 155 feet, including 15 feet vertical upstairs. And this is a carpeted stairway, which is not supposed to be unduly damaged by any of the owners, and that's in our CCR. So some of these facts need to be verified. Unfortunately, we do not have, a good representation. We have not met. We cannot come here and put together, a great presentation because we're all business people. We're trying to do our work. This is not business for us. It's overhead. So I think all of you as commissioners of the city need to consider the impact it will have on all of us at this facility. Thank you very much.
Thank you. I think I saw some other people stand up. There we are.
Thank you. I'm Justin, current owner, and I oppose this 1841 application. As an owner, I feel like it's not compatible due to the fact that obviously we've mentioned this many times about the CCNR's section 2-1 that says reiterates the purpose of the property is a condominium project consistent of a land and a two-story office building. And really, the only way I feel like it would work if they actually if they stored everything somewhere else. As you can see, there's a lot of people that have stood up here to oppose this, and there's not as many people being pro this, the other owners. So also, I feel like it's a detrimental impact to the owners. There's a lot of talk about, as far as pricing going up and so forth, and I beg to differ. Based on a business like my own that's a digital agency and other people that are not in the cannabis space, it may go for the cannabis people, but not for the common folk like ourselves. Also, a big thing is, last time we met, a week ago, there was talk about wanting to be good neighbors, and really I feel like there hasn't been a lot of involvement that I've known from the other owners with the Triad group. As far as connecting with other owners, I haven't. I mean, this is the first time that I've actually seen them. It was the last meeting we had here. Secondly, last thing I would like to say is, I have kids. I have a daughter and a wife who's pregnant as well, and they're always at my office. It's a family business, and my wife wasn't able to attend tonight, but that's what she wanted to kind of contribute. But I appreciate the time, and thank you for your consideration.
Thank you. Good evening.
Good evening, Commissioners. My name is John Chernella. I run a little CPA firm in the corner of the building. Been there for about 10 years now. I'm here to oppose the 18-41. First off, I was a little surprised that these guys didn't knock on every single door in the building before they sent in $51,000. It's surprising to me. I know I would have with those kind of stakes. My neighbors over here, their business is financial planning for Lutherans. I don't know if that sounds like something that would be very pro-cannabis, but I would have knocked on that door. And I mean, honestly, I was equally surprised that these guys weren't coming around for visits after last week's hearing. Hey, what can we do? What's going on? I think, again, though, it's all these guys bought in and agreed to abide by the rules of our office condominium complex. And if these guys come in, it turns into warehouse, storage, shipping, and distribution. It's a totally different model. There's a lot more people running around, and it's troubling. Now, I have no problem if they want to come into the building and be cannabis consultants, if they want to be cannabis attorneys, if they want to be cannabis security agents, would not bother me in the slightest. I'm concerned with product, I'm concerned with wear and tear on the building, and I'm concerned with smells. I know there's supposed to be no smells, but there was, we had from shelf life a big old smell coming out, but I didn't know the mechanism by which to report it to someone at the city. I sent it to our management company. I'm happy to forward you the email. And it happened to be a day I had clients coming in to visit me in the building, and it doesn't look great. Anyway, that's about what I have to say about it, and thank you for your time tonight.
Thank you.
I tend to run along last time. I'm Greg. I'm also an owner in the building. I'm here to oppose the application as well, primarily based on two things. One is it's substantially incompatible with our building. Number two, it's detrimental to the other owners of the building. So they talk about one thing where the CCNRs don't provide a laundry list of prohibited uses, but our CCNRs are very clear about what the acceptable use is, and it's very specific about it's an office condominium. That's what it says, if you care to look it up. Number two, I think it's detrimental to the other owners. I've been there for 12 years. I've invested and taken on debt well over $2 million to be there. I don't see the property values going up in my space at all. Matter of fact, there was another owner of a similar size space, smaller than mine, who the rest of the city for a business office use could get about $450 a foot. I think she sold for $350. That's incompatible with these proofs that real estate values are increasing. I looked at my values. I think they've gone up about 1.25% a year in the 12 years I've been there. So it's not really improving my situation, nor a lot of people's here. We don't want distribution. We don't want manufacturing. We don't want distribution. We don't want warehousing. This is a professional office space. We've all invested significant funds, excuse me, to place our businesses there. This is detrimental to the rest of us. We don't want, and it's not about the cannabis, it's about the use. Warehousing, distribution, manufacturing, totally incompatible with what we're doing. People will be displaced, experts or no, people will leave. They've invested a lot of money. They may not make money. This is something that also has us concerned, because if you approve this case, there's 4 others that are pending appeal. If you approve this case, you will let them all in. You will drag us all into something that we didn't sign up for. And you may cause litigation. And if you do, you may be part of it. This is totally inconsistent with what our CCNRs say, why we bought there in the first place, what we want to represent as a community, professional office buildings. Thank you.
Thank you. Anybody else to speak on this item?
Good evening. My name is William Morris. I am a local real estate agent here in Orange County. I just wanted to give you a little bit of my firsthand knowledge of the Measure X zone and what it's done to property values and rents. Since Measure X has been passed, rents in cannabis-friendly buildings have gone from $150 to $2 a foot to $3.75 and $4 a foot. I've represented a tenant over on Cadillac in Measure X. He's currently paying $3.75 triple net lease. Values have gone up by, in some cases, up 50% from when Measure X was passed in buildings that are being bought for cannabis use. I don't oppose nor in favor of this. I'm just here to give you a little bit of firsthand knowledge of the market. Thank you.
Thank you.
Howdy, Roy Newton. Thanks for letting me talk. Wanted to talk to you against cannabis here in our building. Prior to any single purchase within our building, Travis Castro, the owner of the 3 suites, came to speak to me. I told him I was against it, that I own a federal government business. He told me in turn that this would only be paper pushing. Don't worry about it. We're only going to be pushing paper. It's only a logistics business. Don't worry about it. And to the point of where I was concerned enough in which I employed his real estate agent to find me a space because I thought I may need to move. We went, we looked, we could not find anything within $100 a foot that would be even close to suitable, to the point of where I would need to actually buy something that was 8,000 square feet, which is significantly larger than what I own, and be able to find subtenants to be able to conduct my business. And I must own my space because I have to have a SCIF, secret compartmentalized industrial facility. I am a federal business contractor. So we secure every secret desktop, every server within the U.S. government, within the U.S. DoD, COCOM service agency. My employees are cleared. We have a secure room. We embark on national security endeavors, and we keep this nation safe and our service members safe overseas every day. There is no rule for what is being proposed. We have spoke to DSS. After our first big shindig here, I thought, come on, we've got to figure a way out of this. They said, we don't know. Cannabis is a federal type 1 drug. It's illegal according to the Controlled Substance Act of 1970. You should probably move. We don't have an answer for you. So do we want to take the risk of, do I want to take the risk of my company of being shut down, of saying your clearances are pulled? Because once my clearances are pulled, I don't get them back. That is truth. These people, my clients, are the intelligence community. When you lose your facility clearance, you don't get it back. This is not a 3 strikes policy. This is not a you can do it over again. My clients don't like risk. They secure this nation. And they come and visit me on a regular basis. I can't take this risk. Thank you.
Thank you.
Hi, my name is Stephanie Shields, and I own 2 office suites actually directly near the applicant, 255 and 270. I own a financial planning business for Christians. It's a very conservative business. I bought my first office suite in there about 7 or 8 years ago, and I was ecstatic and thrilled that as a small business owner, I could actually find a business or find an office that I could actually own that was affordable, that was 1,500 square feet. This was an amazing thing within Orange County, and I looked all over the place. And then across the the way, I was able to buy a second office because that's where Flame Broiler, which a lot of you are probably familiar with them, used to be housed. And they actually had to move out of their suite because what they needed to do was put in a kitchen lab within their suite, which was incompatible with our CCRs. And so they had to move out of the suite, so I was able to buy that office suite. So I own those 2 office suites, and I'm just extremely distressed by this entire situation because if they are able to do distribution, I will have to move out of the office, move out of those offices, and it is very unlikely I will not be able to afford another office space. And yes, values might have gone up and rents might have gone up if you're a cannabis business, but I'm not planning on ever going into the cannabis business, so that really doesn't mean a lick of difference to me. And I don't want to turn around and sell my office suite to a cannabis business and hurt the rest of the business owners in mine. I am an ethical person and I refuse to do that, so I wouldn't sell to a cannabis business. A couple of other things around the CCR. That was one thing I spent a lot of time reading that big report, and in there it says that no part of the covered property shall be used which may cause any unreasonable emission of odors. We have already had at least a half a dozen times we've had to call our homeowners association because there was a smell of pot in the building, and several of those times were identified by some of my clients. Talk about embarrassing, because I hadn't been actually out in the building and they smelled it. And since I am right next to the office, and there's no way our HVAC system, and we actually have a expert Biagio air conditioning, and we'll pass that out to everybody, that says that our HVAC system is not, if there's a smell within one part of the building, it doesn't matter what you do, you're going to smell it elsewhere. Our entire building is connected. And I know they're saying supposedly everything's going to be odorless and sealed, but that's like saying odorless garlic pills are odorless, and they're not if you ever open up one of those containers. So I'm just not quite buying that. Also, it's saying that it's not supposed to, in our CCRs, violate any applicable government law, rule, or regulation, and that is an issue because it is federally illegal. Thank you.
Thank you.
Hi, Commissioners. My name is Kimber Ward. I actually work with a licensed manufacturer here in Costa Mesa, Yummy Karma. I'm actually just speaking on behalf of the industry, not my company this evening. So we're a manufacturer. We've never had any issues as far as odor goes. We actually use the clean air system that the applicants have spoken about this evening, and it's entirely self-contained. We work in Building O of Cadillac Park, so we're in a multi-unit structure, and we have upstairs units directly above us. We've never had any issues with them telling us that we have odors above us. They are a cannabis industry, but they are within the cannabis industry, but they are building out so they would actually be open to our HVAC system, and we haven't had any issues. We are a manufacturer. We've had some opposition within our park, but we've been nothing but great neighbors. As far as the way that this structure of the business was actually set up, all cannabis companies were actually set up in the mutually beneficial nonprofits prior to MAURSA, is what that acronym means. And so since we are actually able to change it, we did change ours to an LLC prior to coming in front of you guys, but that's how the entire system of our industry was set up. We have not had any issues as manufacturers here in Costa Mesa, and we've done everything that we can to be fully in compliance. I'd be happy to answer any questions whenever it comes to the actual industry, because we have been up and operational, fully licensed since October of this year. So that's all I have to say. Thank you.
Thank you. Good evening.
Good evening. I'm Catherine Roulette of Nacy Roulette. We represent the association. This building and the CC&Rs existed before Measure X was passed. Lest there be any confusion, the association has never approved or agreed to cannabis operations in the office building, and there are no operations involving cannabis, just to make that clear. In fact, Whatever the real estate agents may have presented to the public or to Triad, that is not a representation by the association. The only thing that has been clearly represented are set forth in the CCNRs. And that was something that everybody has notice of, including all the tenants and the owners. And that is what the owners have operated their businesses under those regulations. The sole nature of the property as set forth in the CCNRs, which has been stressed by everybody, is it's an office building. There is no logistics facilities, there is no warehouse or distribution occurring, and there is no illegal activity permitted on the premises, which currently includes anything related to a Schedule I drug under the federal laws. I believe Commissioner Zick previously noted that parking is packed. The commission has required a designated loading zone subject to the association's approval, which was never given and may not be given, in which case will the CUP, if granted, will that be revoked? There's also a concern about additional expenses and damages, which may be necessitated by the required for them to comply with all the laws. The association in sum believes that the proposed use is not substantially compatible with the nature of this office building and the businesses operating therein. We believe granting the CUP would allow use which is not in accordance with the specific plan and use of the property. Thank you.
Mr. Chairman.
Thank you. Yes.
May I ask two quick questions? Three. The first is foundational. You represent the association?
Correct.
Do you know what year the association was formed?
I do not. We were recently retained. I'm with Nacy Roulette.
Okay.
We appeared last week.
And do you know when the building was built?
I do not.
Okay. Thank you.
I just represent the association. Thank you.
Yep. Thank you.
All right. Any other members of the public here to address this matter? Okay. I'll invite the applicant back up if you want to rebut or provide any closing. This is your opportunity.
So I think that there's a couple things that perhaps I'd like to sort of clarify about our intentions for the business, why I think that we can be good neighbors, why I think that we have tried to be good neighbors up to this point. And then I would also maybe address some of the individual items that were raised. But I think that there's, I think, potentially a misunderstanding amongst our neighbors about what we want to do there. One of the concerns that was raised was sort of the image of a large distribution FedEx type facility with people going up and down the stairs all the time. That's not at all our intention, and we have presented in great detail at the last hearing that the scale of our business is really 1 or 2 or 3 trips each day up the stairs, 1 or 2 or 3 trips each day down the stairs with one container that can be held by a person. It's not a lot of traffic in and out of the building. We'll be seeing far less traffic generated in our suite than someone who sees clients all day long. We want the issue of parking. We intend, like any small distributor, to have our shipments go out in the morning, and so our outbound shipments go out in the morning, and our shipments that come into our facility will come in at night, so that there's not, again, going to be any material disruption. With respect to the issue of odor, we do have the samples of the products. We have a detailed odor mitigation plan in the event that there was some event that could cause an odor leakage, but the products themselves are and always will be odorless. And so the nature of the air conditioning system isn't really germane, especially since that we do, as we presented in our original presentation, have a detailed odor mitigation plan. One of the other things that I think there was, probably not intentionally, but that was created a picture of us not, trying to interact with the HOA or try to interact with our neighbors. And I think, there's the way we started this, we looked all over for a place to do business in, try to buy, try to lease. We wanted to do business in this space. And the very first thing we got when we got to this particular facility was an email from the HOA representative. And I think that's in your packet, and it's at page, I think it's at page 85, but I have a slide on it, Caitlin. Part of it is, I think, slide 13. Sorry, it's page 95 is the email. So, of course, we would not want to invest our time and our money into a place where we weren't welcome. And we had an email, and we never heard anything from our landlord, obviously, that there was any hostility towards our businesses. But the email that we got is from Mr. Brent Haskell, who we understood is and continues to be the sole representative of the HOA in terms of speaking to people on behalf of the HOA. And what he said was, some of you may or may not be aware of Measure X. I've attached some links to info on this measure in red below. And so he provides the links to the measure, and he explains that he says this outlines parameters, describes many of the operating standards like odor control and security elements. And he says here that a thorough and extensive review of the operator, operation, security, and safety plans, and he has that link. Then he has links to the state regulations. And he explains that the comment period's over and that there's a cleanup bill in process. And he says that he explicitly addresses the CC&Rs. He says, 3525 Highland Avenue has been zoned for certain types of uses in the marijuana industry, spelled out in the links above. Currently, the CC&Rs do not contain language that would prohibit those business uses in the building. This is one reason the board has elected to remain neutral on this matter, but inform the owners as to what is happening. So we had this, and we took this as, we relied on it. If we had received a different communication at any time from any of these people in the last year, we could have changed our plans. We really can't change them now. We've invested hundreds of thousands of dollars in rent and in application fees and in consultants. And the main thing is that our ability to get a license somewhere else is kind of gone. That ship has sailed. We relied, and we were in constant communication, as was the staff, with the head of the HOA, this Brent Haskell, on the issue of parking. And the HOA cooperated to facilitate a parking study at the building, which concluded that there was 50 additional spaces, sufficient so that they could, if they chose, give us the parking space that us and Shelf Life were requesting. Shelf Life was in that building operating as an office for a year. They have told me, and of course I would have no way of knowing this, but they told me, and I believe them, that they never had any cannabis in their space, period. That they were being good neighbors, but that they had told people what they were going to do, namely operate a distribution facility. They were absolutely blown away to hear from their neighbors for the very first time the sort of the depth of the opposition to their application. They like us, had rented the place for a year, trying to wait their line, wait their turn in line to get their application. And they, like us, did not know about this opposition really in any time to do anything about it. Since the last hearing, the very next day we did reach out to the lawyer on behalf of the HOA, and we said, is there a path forward here? We do want to be good neighbors. Can you let us know if there's a path forward? And we got no response. So I'm not sure how germane that is to the issues that the planning committee has to decide, but just from a standpoint of us being good people or trying to be good actors, we tried to play by the rules. We've tried to be in contact with people. We never understood that there were any issues until that shelf life hearing. And, this isn't like we're, we will lose our company if we don't get this a business approved, and we don't want to be bad neighbors if we do get it approved. The safety issues, I think, are understandable, but they're a product of the time period when the business was an illegal business. And, the image of cannabis companies as, sort of beacons of unsafe behavior is not fair and has been, I think, thoroughly debunked by the city's consultants. And I believe the police department is here as well. If there was questions, that I'm sure they could field them. The issue of the facility clearance, it certainly is something that, one of our charities our only charity that our company supports officially is a veterans charity. So it's not like we don't care about national security. And that's why we went and hired a lawyer who went and spoke directly with DSS. Mark Zaid is the #1 lawyer in this field, and he went and he confirmed that there is no policy. And he also went and talked he said, look, if this was a real concern, it would be a legitimate concern. I'm not going to, I'm going to look into this is what I'm going to do. And he did. He went and talked to the very people that run the show at the DSS, and they said, yes, there is a federal policy against people that have a security clearance engaging in smoking cannabis. So if a person were to smoke cannabis, that person could lose their security clearance. But he said that the DSS specifically told him that there is no policy and no plan to have a policy that would cause someone to lose their clearance by virtue of their proximity to a legal cannabis business. He also confirmed that if there was such, if it's that big a concern, then moving out of Measure X altogether is probably more appropriate, because there's cannabis businesses all over Measure X. So whether they're in the building or whether they're next door or whether they're across the street, the security concern would not be ameliorated one way or the other. But the bigger issue is that the people at DSS confirm that there is no policy. There's no policy being discussed, and there's no threat of someone losing their security clearance. We, on the other hand, will lose our business. I don't know if there's anything else I can address. I think I've tried to address, in a brief and respectful manner, all the comments.
So I'll just make a few final points. Dan Bain, I'm an attorney at Shepherd Mullen. I represent Triad. Commissioner Zitch, just to answer your question, the building was constructed and entitled April 14th, 1986, and it was entitled as a research and development business, and it's in an industrial zone. So I understand it's currently being occupied by folks who are professional services and all that, but the intended use of this building was for R&D and industrial type uses as well. So that's what we're proposing. I'll just, again, remind the commissioners that, you have to deal in substantial evidence, and substantial evidence is not just anything that anyone says, but it's, when you're talking about expert testimony and things like that, whether it's a DOD clearance or odor issues and how to deal with that or security, you have to rely on experts. And I understand the concerns of the members of the public that are concerned about odor, noise, safety, all of these different issues, but being concerned about what may happen in the future is not substantial evidence. And this is a conditional use permit, so at some point in the future, if there ever is an odor issue or ever some sort of a security issue and my clients aren't complying with their conditions of approval, they'll be held before this body again and you'll be able to address that. But right now, dealing in what could happen in the future in light of the substantial evidence that's been presented, I think would be inappropriate. And frankly, it's been contradicted by virtually every expert that's been up here to speak, whether about the odor issues or otherwise. Just go back through my notes here. I did reach out to Mr. Nacy, who came and spoke last time. I asked him if he'd like to have a meeting with my clients and set up a meeting with the board of the HOA to talk about our application if there was a path forward. So I just echo what my client has said already, is we have reached out to them on a number of occasions. I've been in contact with Mr. Nacy via email or otherwise. So we've done everything in our power to try to work through a path forward. And just the last point on the substantial evidence, if the DOD or the DSS had a concern, or if the client that had that security clearance had a concern, I would have expected a letter from the DSS or the DOD expressing those concerns. We've had ample time to do that. We've submitted our own letter. You haven't seen any letter from DOD or DSS, and I think that sort of silence is deafening when it comes to whether there really is an issue here. Thank you.
Commissioners, any questions for the applicant?
Yes, I have a question for the public speaker. I'm sorry, who just spoke on behalf of the applicant. For the letter that you submitted from the attorney, I just want to point out that in the fourth paragraph, page 2, last sentence, of course, I do not speak for any agency of the federal government and cannot predict or promise that this outcome to be, but were any U.S. defense contractor to retain me to address this issue on their behalf, I would provide identical legal and policy advice. And so, you know, I appreciate that you took the time to try to contact an expert, but your expert has explicitly stated that they do not speak for any agency of the federal government. And so just as you requested some sort of letter from DSS, I'm surprised that you didn't get one directly from DSS yourself. Did you guys attempt that, and why were you unsuccessful?
Well, because we got an expert report from somebody who deals with the DSS and the DOD. I mean, this is his job and what he does for a living. And so for us to go to the DOD, we hired an expert to do that on our behalf, and that's exactly what he did. And so, sure, he said at the end that he can't speak on behalf of them, but he did speak with them and has extensive experience in this industry, and this is the letter that we got out of him.
Okay.
So if there were an issue,
then there were, but you haven't directly spoken to a member of the federal government.
No,
DSS specifically.
a representative.
Someone that considers themselves an expert.
Sorry, so to finish, our expert that we retained did speak directly with DSS and DOD, so we did have a representative speak with them on our behalf.
Okay. Okay, and I'll tell you the problem that I have with that is I work for a state agency, and typically if someone wants to know something or request information, there's a lot of ways to do that. And we are always required to provide the information that's requested. And so there are ways for you to request this kind of information from the federal government, and for whatever reason you chose to retain someone that is an expert rather than obtain the information that you wanted directly from the government.
Well, that's exactly what you do. So if I go to court, my client would hire me as an attorney who's an expert in dealing with the court, with the procedures and the sort of the nomenclature. I wouldn't expect any client to do any different than to hire someone who's an expert in dealing with DSS and DOD. I think it would probably have been a bad idea for them to reach out directly to DOD and DSS, not having the expertise and the knowledge and the nomenclature and how to actually express the issues that are presented. So I disagree a little bit, and that I think it was the best course of action to actually hire an expert. And had they talked to them and come to you and tried to provide substantial evidence, they wouldn't be giving you substantial evidence because they're not experts in that field. So that's what we're trying to do. Okay. Thank you.
Any other questions for the applicant or any of this?
Mr. Chairman, just, and whoever can answer it. So are condition 40 and 41 non-starters for you? Well, could you please come to the podium if you want to answer
it? What we advanced were the conditions proposed by Commissioner Zich. So
but my question was, are 40 and 41 non-starters? You can't live with them.
So I just answer that question by saying we can't live with them because I think the HOA's counsel has already stood up here and said the HOA is not going to give them a designated parking spot. And the CCNRs expressly prohibit designated parking spot to members of the HOA. So
And that's a fair point. So my next question would be, the CCNRs also prohibit on 145 in restricted uses, Article 8, 8.1, E violates any applicable government law, rule, regulation, statute, or ordinance. Cannabis is a Schedule I narcotic, and under federal law, it is illegal to distribute it and sell it.
So
Why does that provision not apply?
It doesn't apply because state law expressly allows it, as do the Costa Mesa Measure X ordinances allow cannabis uses. And I just back up, and we had a discussion last time about the CCNRs, whether that's something that is normally within the purview of the Planning Commission to address. And what I would ask is that's really a private matter between the owners of the units as to whether the CCNRs prohibit the use, and that's something we would certainly take up with the HOA. I expect to hear that. But no, our position is the CCNRs absolutely do not prohibit our use, and I think that the HOA's representative and correspondent has already previously confirmed that fact as well, stating it does not prohibit those uses.
Any other questions for the applicant?
No.
All right. Seeing none, I'm going to go ahead and close the public hearing. Commissioners, somebody want to make a motion for purposes of discussion?
Mr. Chairman?
Yeah, go ahead.
I'll keep it a little shorter, I think, than last time. I'd like to move that Planning Commission adopt a resolution finding that the project is exempt from the provisions of the California Environmental Quality Act, CEQA, under their guidelines 15301 Class 1 existing facilities, and adopt a resolution to approve planning application 1841, subject to conditions of approval with modification to conditions 40 and 41 as follows. Condition 40 would read, any activities relating to the loading and unloading of cannabis products shall take place in an area that shall be monitored by security cameras at all times, located no further than 150 feet from video cameras location. And condition number 41 would read, all loading and unloading activities specific to this use shall be limited to one delivery vehicle at any given time. And I've got some comments if that gets a second.
All right, I'll second the motion. Comments on the motion, commissioners?
So similar to my comments at the last meeting, I felt that we have an obligation as a planning commission to find certain points of fact to either support a approval or support a disapproval. The first being to find that the proposed development or use is substantially compatible with developments in the same general area and would not be materially detrimental to other properties in the area. And it was my feeling that this was very straightforward and really of the three conditions, probably the simplest. I still feel that this is an activity that if one physically observed what was going on, would really be not much different from any other office type activity. The fact that there's no packaging, no repackaging, no testing of cannabis materials, I think makes this use substantially compatible. Now, I recognize that there wasn't a single owner of the condominium complex that agrees with me on this. And I find that the reasons they don't agree are a combination of risk concerns and reasons that I'm not quite able to understand well enough to agree with. The couple of speakers that spoke with the security business, the government security business. So I have a great deal of familiarity with that area. And I know as a matter of fact that you do not need to own a building to have a government certified SCIF in it. You can lease a building and have a government certified SCIF in it. I built hundreds of SCIFs, DOD closed areas, SAPSAR areas, SCI areas, and I know this. But what you state is a valid risk. Your concern about losing your certification, your facility certification, I get that. But with that risk goes an evaluation, both the probability and consequence. So what is the probability that that would occur? Clearly the consequence of you losing that is great. Your business gets maybe shut down, or maybe you're required to make additional modifications. But I'm not able to fully accept that that risk exists high enough to disapprove this application. I just don't feel like there's enough evidence that I could really point to and say, this is why this application should not be approved. The discussion about the building being an office, condominium complex, office being the emphasis, and that somehow the activity by this applicant is inconsistent or incompatible with that. Again, I'm not really sure I would agree with that. And I think if you look at the history of the building's construction, its descriptive purpose at that time, the zoning in which that building was constructed, and the fact that it wasn't until 2005 that the association was put in place and the CCRs, and then this term of office complex becoming more prevalent in use. And I'm not sure to what extent that really has a bearing anyway. The property value concern, I think, is certainly a legitimate concern, but I don't think it's one that necessarily sways me one way or the other. I think the person that commented, and several have, but that runs the financial planning business, the fact that it's sort of like a paper gain of if stocks go up, you didn't actually make money until you sell it. But if you're not interested in selling your business or selling your home, it doesn't matter what it's worth. So the argument that property values have gone up may be well and good, but I don't think that strengthens the argument for the applicant being approved. But the converse is what I find, which is I don't see the property values going down, which takes me to what the second finding is. And that second finding says, granting the conditional use permit and minor conditional use permit will not materially be detrimental to the health, safety, and general welfare of the public or otherwise injurious to the property or improvements within the immediate neighborhood. Well, certainly I don't think there's any detrimental impact to the health and safety, but it's the aspect of, is it injurious to the property? In other words, in my mind, does it decrease the property value? I don't think there's been any evidence that that would occur. So again, relative to this finding, I think it supports an approval as opposed to a disapproval. The third says granting the conditional use permit and minor conditional use permit will not allow a use density or intensity which is not in accordance with the general plan description, any applicable specific plan for the property. Kind of a generic item. I don't think that this conditional use permit would. You know, I'm not a big advocate of these cannabis businesses, and I'm not opposed to these cannabis businesses. But I look at the application, I look at what they're proposing to do, I look at how they're trying to manage the loading, unloading, I look at how they're trying to manage security, I look at how they're trying to manage odor control, I look at how they're trying to manage compliance with all the state regulations and the city regulations, and I just can't find anything in this applicant that makes me feel like it should not be approved. So that's a long way of saying it, but I just cannot find something to hang my hat on that I would feel comfortable saying no. Thank you, Mr. Chairman.
Any other comments on the motion, commissioners?
Mr. Chairman, first of all, I want to thank the applicant and staff for looking into the nonprofit issue and the taxation issue. My whole concern was whether or not, and I didn't know at the time, whether or not a nonprofit engaged in adult use cannabis distribution, whatever it is, could somehow find an exemption on paying gross receipts tax, which is not a sales tax. It's a tax on the actual business, the gross receipts of the business. So I'm satisfied with that, and I appreciate the effort that you explained, and I appreciate staff's information as well. Still can't support the motion for a variety of reasons, and I think I'm going to take the exact opposite side of the coin from Commissioner Zick. I think the proposed use is substantially incompatible for a whole lot of reasons. One is when we started this process of listening to these CUP applications, we had staff in its professional expertise and its experiences in dealing with complicated land use applications and a brand new industry that on the one hand the state says is legal, on the other hand the federal government says is illegal. Locally we say it's legal, and we've even created a zoning mechanism for it. But we created some standard conditions: armed security, designated parking, and those by meeting those conditions, you kind of create this. Okay, we're creating a compatible environment for this use to exist here. Well, now we're getting rid of them. We're getting rid of no armed security. We're fudging on designated parking now, not because it's particularly onerous, but only because in this particular instance they don't think they can get permission. And so that bothers me. And then I look at the actual language in the CCR, which essentially says no use shall violate any applicable government law, rule, regulation. And despite what counsel says, in my mind, I can make a finding that says that the use will be injurious to the property because it could be injurious to the governance of the property merely by violating the CC&Rs. I know we've talked about, this is just a distribution business. There's no labeling. There's no packaging. Everything will blend in and nobody will know. I know for a fact that the cannabis industry knows exactly where this zone is in California. This is the hotbed of cannabis manufacturing. Everybody knows what's going on in this zone. And if you concentrate enough businesses in here, which I have no problem doing as long as they're compatible, you're going to have vans. Once we fill this place up, you're going to have vans coming and going with monitored security and cameras pointing here and there all over the place. It's not going to be like it's a secret. So, and if you get enough businesses in here and everybody's doing 2 to 3 deliveries a day or a week, there's going to be quite a few deliveries going on. So the blending, I can't buy into that. And then we've gone from state law that says basically they want a video camera on that can spot anywhere 20 feet within an exit entrance. And we've gone from what I perceived was when we first started approving some of these with a designated parking spot, it was these spots were like immediately adjacent to the businesses. Now we're stretching out to 150 feet. And I don't know that there's going to be a spot within the 150-foot rule any given time of day with all these vans coming and going. There's 4 or 5 other applications that are going to come in their building. They're going to want parking spaces. How do we know one's going to be open within eye shot of the cameras at any given time? And what do you do if it isn't? So all of a sudden we've gone from this kind of all figuring out, let's get our arms around a fairly, it's a rigorous regulatory regime right now. And like I said, if Schedule 1 listing of cannabis goes away, I'll be the happiest guy in the room. We can all breathe a sigh of release and relax a little bit. But until it does, I just, we're now fudging on the parking requirement and the loading and unloading. And I don't know. How do we guarantee that there's going to be a space available within earshot of, or eye shot of a camera? And if it isn't, what does it do? The van drive off and you reschedule the appointment? I don't know. It's just really kind of all of a sudden gone from where I thought we had our arms around this and we were controlling it pretty well, and let's give it time to work and see how it's going to work, to where now all the rules are just kind of unraveling, and we're just to let this applicant get to where he needs because the state's saying you're going from, your license is going to run out, you're going to have to get in the back of the line, and so everybody's panicking because they got a ton of loot invested in this. But investing in a business is not a guarantee. You put capital at risk, and sometimes you win and sometimes you lose. So I for those reasons, I can't support the motion, principally because from a findings perspective, I do think that the use, which is the distribution of a federally prohibited narcotic, violates the CC&Rs and therefore is injurious to the property from a governance perspective. Thank you, Mr. Chairman.
Any other comments on the motion?
Yes, Mr. Chair. First of all, thank you all for coming back a second time. I apologize for my illness last week. I don't necessarily feel like the swing vote here because I had read the materials last week. I watched the video. I visited the site a couple times. I went back and read Measure X again. I probably spent more time thinking about this than many planning applications in recent memory. What I started with, though, is that Measure X was obviously ballot box planning, which is always rife with ambiguity and complexity. And even though the intent of Measure X was to provide a zone for this industry, and largely to be put in an industrial area, which typically in communities is residual land, stuff we don't really care about because it's far from residents, there wasn't much of a comprehensive regulatory scheme here. So the bulk of the heavy lifting has fallen on city, and in particular city staff, and to a lesser extent the commission and the city council in trying to interpret some of these complex issues that have come up. I'm persuaded by some of the comments by Commissioner Zick and his analysis, yet at the same time I think Commissioner Derrickle offers a fair amount of wisdom on this topic as well. What I keep going back to is that Measure X required a conditional use permit for businesses. It's as simple as that. There is no business by right here. And I'm glad that Commissioner Zick brought up the issue of risk, because I happen to represent developers and property owners in real estate and land use issues. This is my daily work. And anytime they venture into a discretionary area, it becomes how much risk can you tolerate? I always try and encourage clients to do whatever is by right because we have some certainty here. And unfortunately, we don't have a lot of certainty in this particular issue. We have a number of new issues that are coming up that, and I agree with Commissioner Derrickle, it seemed like we had a pretty good handle because we were dealing with the premium properties. These were the ground level entry for roll-up doors and parking, fully secure, all within industrial complexes. And now we're moving into second tier, third tier type buildings where we're being asked to look at second floor access, non-designated parking. I think it requires a bit more rigor in trying to analyze these. So I go back again to Measure X and its intent, and I think it was to create an area within the city to provide for cannabis industry to take root. But I don't think the intent was to necessarily displace existing commercial businesses. I don't think the idea was to try and create a zone which encouraged people to sell existing properties necessarily for cannabis-related businesses if they had existing, successful, manageable businesses. And so where I see it here today is we've got, I don't know how we get around it, is an existing commercial office building. I mean, you look at that and all the businesses there, everybody who spoke tonight, I think it's telling that there wasn't a single tenant who offered any sort of support here. I mean, clearly you're in a building that you have your neighbors who don't particularly want you there. And I think for legitimate concerns. I don't think that they are being arbitrary here. And I should note that none of those businesses have CUPs. They're all there by right now. So I'm hesitant to introduce a new business here that is asking us to do a lot more heavy lifting and trying to effectively fit a square peg into a round hole. That's not to say that every other project that comes before us won't have different kind of consideration, but I'm troubled by that here. I do want to make one point, though, and I think it was Developers Council, Applicants Council may have mentioned, drawing our attention to the email from the association's representative. I should note that from my analysis, I don't really care about the CCNRs. That's a private matter. You could very easily get a CUP from the city, but effectively end up in litigation or a dispute with the property owner, and that's of no consequence to me. I find it troubling, though, that we're being asked to look at the CCNRs for certain guidance, but not for others. You can't have it both ways. So I note this email because as I read it, there's no guarantee here. It simply says that the CCNRs don't contain language that prohibits, but then in the next paragraph very plainly outlines the process you would have to go through to obtain city approval, which is getting a CUP. It's fairly objective, and I read this as saying you should be aware of the issues before you and that there is no guarantee here. So I know I've kind of rambled a bit here, but I do have to say I can't support the motion as proposed. I think it's asking too much of us right now, and I really feel like on balance that we should take into consideration the existing tenants and their needs here.
Commissioner Woods, did you want to say something, or?
No, thank you. I think I said what I needed to at the last meeting. I stand by it, and I appreciate Commissioner DeOracle's and Mr. Harlan's analysis.
All right. Well, seeing as I can count here, I think what I want to do is propose a substitute motion, and the substitute motion would contain a condition essentially prohibiting cannabis products on the property. I think we could do that probably by amending condition of approval number 1, strike the word distribution, and essentially strike the words between 12 a.m. and 5 a.m. So it would just read, no product distribution will occur. So, and the reason why I say that is because as I understand it, from listening, and this is the second meeting, from listening to members of the public who are all tenants in the building, the main concerns that I have heard are the fact that there's going to be that the odor issues are a main one, and then we had another owner in the building saying that the federal government is going to have problems with having cannabis distribution in the building. So if we remove, you also had, so anyways, and also the parking issue. So we can't get around 40 and 41 apparently. And there's also issues with regards to the way this building is built and the odor control issues in the building. And that is a concern of the other members of the association. So if we essentially get rid of the distribution portion of the CUP, from my understanding is that would essentially that would essentially solve the problems that that Vice Chairman DeErico has brought up with regards to the CCNRs, which, by the way, I tend to agree with Commissioner Harlan on that the CCNRs aren't something that the Planning Commission should wade into as far as taking a position on what those mean or what effect those should have. But my substitute motion, I think, would address the concerns regarding the CCNRs. I think it would also address the concerns of the majority of the members of the public who spoke on this item, and I think it would address the concerns that Commissioner Woods had raised and Commissioner Harlan raises tonight. You won't have any product, you won't have any parking, you won't have any security issues, and so I think that would pretty much resolve it. So that's my substitute motion, if there's a second on that.
Mr. Chairman, if I understand that, and the city attorney can correct me if I'm wrong, I don't believe a CUP is required once you take the marijuana off the property. They can still run the business there as a office, but correct me if I'm wrong, Tarquin, but I believe as you're proposing it, it would basically take the marijuana off the property. CUP, I do not believe would be required anymore at that point.
One of the concerns that I have, though, is as far as the applicant's business is concerned. As I understand it, if they don't have any right to operate there at all, they would essentially be. I don't believe they would be able to get that state license, and that would essentially put them back again. So this would give them the opportunity also to appeal, and it would preserve their right to that state license, and that's one of the concerns that I have. I don't want to see the business essentially fail because of a planning commission decision. I think that if the business is going to fail, that I think that's something that the city council probably should look at. So that's one of my concerns.
I understand that concern. If we take away the distribution portion, that's what they will be applying to the state for, is distribution. They will be seeking basically my authorization confirming that the Planning Commission and the city is approving them for distribution use on that site. And it sounds like you're saying taking distribution out of the picture, and that's what the state's licensing.
Well, I don't think so. I think they'd still be a distribution business. They just wouldn't have any product on the premises.
Understood.
Chair Andranian, the legislative scheme that was enacted by the voters, Measure X, presupposes one that has a CUP as well as a marijuana business permit. And the city can only certify to the state that the business is in compliance with Measure X, that it has both a conditional use permit as well as a marijuana business permit in order for it to get licensed by the state once the state checks with the city. So my understanding is that an office space, a general office space, is permitted by right in this zone. But the city would not be able to issue a marijuana business permit if distribution is not authorized by the CUP or some other Measure X use is authorized by the CUP. So in essence, even if the Planning Commission were to give them a CUP for an office use for marijuana distribution, although not physically distributing the process, just doing whatever office work that didn't involve physical distribution of the process, the city could still not issue a business permit, a marijuana business permit, and therefore the city, the planning department, could not certify to the state that they have local approval, which is necessary for them to obtain approval from the state.
And one other thing, Mr. Chairman, Matt has confirmed that his belief is that the state wouldn't be able to issue the license either because they need to come out and inspect the site for the distribution use on that site, which they wouldn't be doing. I should say Mr. Eaton, I didn't mean to say that.
What if we continue the application and allow the applicant to find an alternative location? I'm open to that.
Similar to the shelf life situation?
Mm-hmm.
I think did we continue shelf life?
No.
No, they were just denied. So I don't think that was.
But I believe Shelf Life was looking into alternative locations, correct?
They are looking at an alternate site, and they will submit a new conditional use permit and application once they find one.
Got it.
No, the public hearing's closed. All right. Well, anyways, I guess the issue that I have. So, if the only option is to continue this matter, I think that the effect of that would be to essentially would be a denial of the application. I think, but I guess we could also do a. See, I don't want to do that either. A denial without prejudice. A denial without prejudice would then be essentially saying that they would be able to reapply, wouldn't have to pay the reapplication fees. Is that true?
Essentially, they could reapply within a 6-month period of time. They wouldn't have to wait for the 6-month window to elapse. However, if the applicant was to appeal your decision, whether you deny it or deny it without prejudice, more likely than not, the city council would take a final action on the application. Otherwise, they could remand it back to the planning commission. But more likely than not, they would either approve or deny the request and give the final answer to the applicant at that time.
All right. Okay, well, I guess, do you want to say something?
Yes, I thank you, Mr. Chair. I mean, if time is of the essence here, I see no point in delaying the matter. We should make a decision, allow the applicant to make a determination about whether they want to appeal, excuse me, or do whatever, or perhaps have the council pull it up for review. But let's leave it up to the applicant to make the decision. It's clearly their application.
Again, on that denial without prejudice, exactly, just so I'm clear on whether or not, so they would have 6 months to, they could appeal that decision, right?
Yes, Mr. Chairman, they could appeal the decision, or they could, if it's without prejudice, they could submit a new application sometime in the next 6 months.
Sometime within the next 6 months.
That's correct.
All right.
Mr. Chairman, one other thing, and Ms. Lee, if you could help me out on this. One other alternative would be, I believe there's an appeal going to City Council in this building. That's correct, right?
That's correct. Schedules for January with the City Council.
So one other thing the commission could do, and I agree with what Mr. Harlan said and your line of thinking, is to try to do this as expeditiously as possible. The commission could continue this till after the council hears the other item and then have input from the council on how it decided that other application on this property before you make your final decision.
The item that's under appeal to the City Council, isn't that for manufacturing?
It's both.
It's for both, actually.
Yeah, I think I think that's a considerably different use than what's being proposed here.
But it was two separate applications, right? One application was manufacturing, the other one was distribution. There was a door between them, but that door was going to remain closed. Correct? Is that right?
That's correct.
They were separate applications.
They were separate, but they were companion operations.
Right.
They weren't as standalone as Shelf Life or as standalone as Triad.
Correct, but should they decide that maybe distribution is okay in this building, then that part of the application would remain viable, or at least that application would remain viable, and the other one may not. Or, it could be that they like both.
All right. Well, then I'm going to make a motion to that we continue this matter until when is that? 15th? Yes, it's a substitute motion.
January
sorry.
15th.
I'll withdraw my other substitute motion, and then I'll make a substitute motion to continue this matter to the Planning Commission meeting that is directly after the City Council hearing on the
15th.
On the 15th.
What date is that? Let's continue to a date certain. So.
Right, we'll continue it. We have, I believe it's January 24th. Julie, will you confirm?
I think it's January 28th. Our first meeting is January 14th, so 14 days after that, then would be the 28th.
January 28th is our second meeting in January. The council's action is scheduled for their January 15th meeting.
Yep. Mr. Chair, I don't know that this is going to accelerate matters for the applicant here. And quite honestly, I'd like to give them as much time as possible to either figure out what they're going to do with this application or a new application or appeal.
And I'm not certain about that either, to tell you the truth. So, you know,
I prefer to leave it to them to figure out how they want to proceed next without delaying till a date uncertain after which we may not actually have any guidance from the city council.
yeah. Well, anyways, that was a substitute motion. If it dies for a lack of a second, then it dies. No second? All right.
Mr. Chairman, I'll make a substitute motion to deny the application without prejudice because the commission cannot make the required findings in the staff report.
I'll second.
All right. A motion and a second. Any discussion on the motion? All right. I'll call for the question.
That motion carried 3-2 with Chair Andranian and Commissioner Zick voting no.
All right. That decision can be appealed to the city council and becomes final in 7 days. Thank you. All right. Where's my... Looking for my agenda. Got a mess of papers. All right. Public services report.
None this evening, Mr. Chair.
Development services report.
My staff and I just wanted to wish you all a Merry Christmas and a Happy New Year.
Oh, well, thank you. City attorney.
No report.
No report. All right. Well, then I will adjourn the meeting to the next planning commission meeting on January 14th, 2019 at 6 p.m. Right here at the Costa Mesa Senior Center. So everyone have a happy holidays and a happy New Year.